Well, hello everybody, and my name is Pat Ammons, and I'm the Public and Media Relations Director here at the U.S. Space and Rocket Center, and thank you all for being here today and for attending the symposium. I hope it's been really informative. I know that I certainly have learned some things as I've sat in on these sessions, and we're all abuzz about it in our offices and our staff, just talking about all the things we're learning. So we are appreciative of you being here, and I have the pleasure of introducing to you today Eric Moore, who is going to talk to you about patents and AI. And so just a little bit about Eric's background. He is a law partner at Patterson and Sheridan, which is a firm that has just established an office here in Huntsville. So we are excited to have them here as part of our community. I do have to also point out that Eric is a Space Camp graduate, so welcome back. We always love to see our alum going and doing great things. So Eric is a fierce advocate for his clients' intellectual property, whether liaising with the United States Patent and Trademark Office or advising on patent litigation. He prepares and prosecutes patent applications for communications technologies, complex software and information technology, and electronics and semiconductor technologies. Eric has worked within the computer science discipline for more than a decade, first entering the field as a developer of military software. He has a degree in computer science from the University of Alabama in Huntsville, just right across the highway here. As a result, he possesses a deep understanding of computer-related technologies and now leverages his insight to support software companies in their efforts to improve the lives of millions. He often assists clients in identifying patentable, that's a hard word to say, patentable, subject matter through inventive mining sessions, helping them translate ideas into viable applications. So I'll let him tell you a little bit more about himself, including he has a law degree from Ave Maria Law School in Florida, I believe that is. And so please welcome to the stage, Eric Moore.
Good afternoon. I am Eric Moore, and I'll be speaking to you today about patents and artificial intelligence. So that is me up there with the red circle. About 25 years ago, I was fortunate to be able to attend Space Camp and Space Academy right here at the U.S. Space and Rocket Center, and I loved it. It was a transformative experience. I definitely recommend it to any of you who have children, or go to adult space camp, which I'm hearing is a thing, and I'm actually really interested in. So I've been thinking about technology and space for a very long time, as you can see in the picture. I've also been thinking about AI for a very long time. I went to UAH and studied computer science, and I wrote an interdisciplinary research paper about making artificial intelligence appear more human through the introduction of pseudo-randomness. It was some theory that I had that if AI is too perfect, it's clearly not human. So if you introduce pseudo-randomness, which is a computer approximation of randomness that's based on some sort of seed data, a certain amount of that will make the AI function in a way that's more similar to the way that a human would address that particular problem. And my very simplistic, rudimentary research did confirm that thesis for what that's worth. So I practiced as a software developer for a few years here in Huntsville, and then I went on to law school and moved into patent law. I was at the U.S. Patent and Trademark Office in 2015 and 2016 as a patent examiner, and then I started at Patterson and Sheridan, which is an intellectual property and technology law firm headquartered in Texas. And as my introducer just mentioned, we opened an office here in Huntsville this week. We just announced it. I've been here for a little while working remotely, but now it's official. Patterson and Sheridan has a Huntsville office. So AI, obviously, as we all know, because it's why we're here, has been a game changer in a lot of ways, and certainly in the legal field. And a lot of areas of the law are scrambling to figure out what to do about AI. And there are 127 countries have passed laws including the words artificial intelligence just in the past year. And there are all sorts of questions being asked. Some of them I've put here on this slide. Can attorneys use AI to assist with work? Obviously, you can imagine the issues that might come up there with confidentiality and ethics and accuracy, things like that. Can AI be trained using others' intellectual property? Is AI entitled to any legal rights? Can AI invent? And are inventions relating to development and use of AI eligible for patent protection? So my presentation is going to focus on patenting AI-related inventions, but I'm going to touch on a lot of these other questions along the way. So let's start with talking about patents. So what exactly is a patent? A patent is something that gives an inventor the exclusive right. Well, what it is a right to exclude, okay? It's not the right to make and use your invention, it's the right to exclude others from making, using, selling, or offering for sale the invention that is spelled out in the claims of your patent application. And it's designed to incentivize innovation and public disclosure of how your inventions work. So in exchange for an inventor telling the world how their invention works, the government will give them this right to exclude. So patents protect intellectual property and they encourage innovation. They have many benefits. So a patent gives the patent holder the right, basically a monopoly for 20 years. And this gives all sorts of opportunities for revenue streams. And sources of revenue can include things like licensing fees, selling patents, selling businesses that own patents. That's a big one. Having a robust patent portfolio can really improve the value of a business. And then, of course, being able to market products that have been patented without worrying about competitors doing the same thing, because they'll have to design around your patented invention or release inferior products to market. And in highly innovative spaces like AI, it can give a small business an opportunity to sort of stake their claim on the market. Because, like I said, it forces competitors to do something different. And also, you can assert your patent. If somebody infringes, and especially if it's a big player that infringes, there can be very large monetary damages involved with patent infringement. But even if your patent never sees the inside of a courtroom, it can be incredibly valuable. So, and this is really more of the same stuff, but the second point on this slide I think is important. A patent portfolio is a defensive tool as well. And so here in Huntsville, we do a lot of research with ballistic missile defense and things like that. I'd like to think of a robust patent portfolio as a good ballistic missile defense system. It sort of communicates, don't mess with us, because we have some firepower. So, obviously, patents provide value and can really be an asset to an organization, but can you patent AI-related inventions? So let's start with 35 U.S. Code Section 101. This is a statute that defines inventions that are patentable. And the statute says, whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof, may obtain a patent therefore, subject to the conditions and requirements of this title. So you look at that statute and you would say, well, an AI algorithm is a process, clearly, or it's a machine that embodies a process. But unfortunately, it's not that simple, because there's a judicial exception to these statutory categories of eligible subject matter. And the judicial exception says abstract ideas are not eligible for patent protection. And what we're talking about here with eligibility is it's a threshold question. We're not yet getting to the issue of have you developed something new, useful, non-obvious. We're just talking about, is this the type of thing that could potentially be patented? And if something is essentially an abstract idea just implemented using a computer, the judicial exception says that that is not patent eligible. There was a U.S. Supreme Court decision somewhere around 2012. It was called Alice v. CLS Bank. And this has been a massively influential decision. It's had a lot of effect on software patents. That was a case about a company that had developed a software program that basically implemented hedging, and which is a well-known economic practice, and it was just done using software. And so the Supreme Court says you can't get a patent on something that is a well-known economic practice that's simply implemented using a computer. And it seems, in that context, okay, that makes sense. But that decision has had a lot of implications on software because of the way that the court framed its decision. And when you're looking at software, it's hard to make the case that there is ever not an abstract idea involved, because software at some level is always kind of abstract. So, is AI an abstract idea? So just like other types of software, machine learning models are often running into issues for allegedly being abstract ideas. Things like mathematical concepts. Is AI ultimately a mathematical concept? Obviously, at some level, code is math. Is it a mental process? Artificial intelligence, just by its very name, makes it kind of sound like a mental process. Is it a certain method of organizing human activity? That's another category of abstract ideas that's been identified by courts. And when you're trying to get a patent on an AI-related invention, you'll often face allegations from a patent examiner or from a competitor or an adverse party that your claimed invention is essentially falling into one of these categories and then otherwise is just generic computing components. So it's created a lot of work for software patent attorneys. So AI-related inventions can be patented, and we do it all the time at our firm. It's just there's certain conditions, and it has to be done the right way. So, for example, an AI-related invention that improves the functioning of a computer or improves another technology is patent eligible. And this is an AI-generated image here of a computer that is smoking, a computer that is in need of some improvement to its functioning. An AI-related invention that includes significantly more than an abstract idea is also eligible for patent protection. And how you determine whether it's significantly more is sort of a nuanced question, but it kind of involves whether there's an inventive step beyond what is done in the known art. So the prior art obviously is what you look at when you're considering whether you're patenting, that the invention you're trying to patent is new and whether it's non-obvious. But there's a little bit of bleed over into the patent eligibility question, because if it's different enough from the prior art, it could potentially fall under this significantly more way to get out of this abstract idea trap. So, when you're drafting a patent application for an AI-related invention, there's a certain way that it has to be done. You need to frame your invention as a technical solution to a technical problem. You're going to want to emphasize the technical benefits rather than the business benefits, for example. You don't want to talk about how, this gives a better estimate for our business, or it gives better content to the user. In some certain contexts, those things can be helpful, but it's not the strongest argument for patent eligibility. The strongest argument is this is better than other automated ways of doing this. Let's say previous automated techniques have these drawbacks, and our invention addresses these drawbacks in these particular ways to overcome technical problems. And that frames your invention well for this whole patent eligibility framework. You should emphasize practical applications. So if you're getting an output from a machine learning model, what do you do with that output? Is it just floating out there in space, or then do you take that output and control some process and have some impact in the real world based on that output? And it doesn't necessarily have to be an actual physical change that happens. You don't have to control machinery based on it. It could even be, changing something in a user interface or something like that. But it's important to have some sort of practical effect of the AI-related process. And you can patent inventions that relate to training ML models and using trained ML models. So training improvements tend to focus on new types of input data, new combinations of input features, new loss functions, new ways of setting hyperparameters and things like that. But when you come to uses of AI, it's all sorts of possibilities. As we all know, having a really good AI model can be used in a whole lot of ways. And a lot of those applications can be patented. And of course, what we've talked about so far is patent eligibility. Once you establish patent eligibility, you then have to go on to establish the other conditions for obtaining a patent, which include things like novelty and non-obviousness. And obviousness is something where if you have a combination of known teachings in the art, and it would have been obvious to one of ordinary skill in the art to combine those teachings to produce your claimed invention, that means your claimed invention is obvious. So those are the things you have to worry about in addition to the eligibility issue. But the eligibility thing is just a unique challenge for software-related inventions and AI in particular. In any type of patent, you're going to need to establish novelty and non-obviousness and some other conditions that aren't quite as complex. So who is patenting AI-related inventions? I mean, there's been a huge surge in patent applications relating to AI. I think 48,000 AI-related patents were granted in the US in the past year. And all of the big players are doing it. We have Samsung, Alphabet, IBM, we have NVIDIA, Intuit. All sorts of major companies are filing these AI-related patent applications. And it's a good time to get in on that game. What types of AI-related inventions are being patented? So the whole spectrum of AI type stuff. We have computer vision, natural language and speech processing, content generation and targeting, medical technology, robotics, training innovations, applications of existing models to new and unique contexts, and many others. So let's take a look at what a claim might look like for a higher level AI-related invention. So in this case, the idea was that if you're trying to classify data from a table, you want to predict not only what the actual cell in that table should be classified as, but also if you look at the header of the column that cell is in, how should that header be classified? So this idea is you have two separate models. The first one is trained to predict the classification of a cell, and then the second one is trained to predict the classification of the column based on the header of the column. And so you provide inputs to those two models, and then you aggregate those predictions to try to figure out the best classification for the cell. And that's what this claim is too, and this is an issued patent. And as you can see, it doesn't have to get into a whole lot of detail about how the model itself functions, as long as there's something innovative about the way that the inputs are provided to the model and how you use the outputs from the model and things like that. And just a little bit of a primer on patents in general. The claims are what really matters in a patent. A patent has several parts. There's a set of figures, then there's a specification that includes a detailed description, and it goes through the figures and explains what's going on. And then the patent application ends with a set of claims. And the claims are what actually gives legal significance to the patent. And the claims generally change as you go back and forth with the patent office. So you file an original set of claims, which is sort of your opening offer. This is the scope that we want protection for. And then the patent office will come back with usually a first office action that has a rejection of your claims. It might have one of these Section 101 eligibility issues. It might have a prior art rejection. and then the patent attorney is going to figure out how to respond to that, and that might involve amending the claims to bring in something else from the specification or to take something out or reword something. But ultimately, the set of claims that gets allowed and issues as a patent, that is what defines the scope of protection. So you see, articles and things like that, Google gets a patent on X, Y, or Z, and they just show like a figure. They talk about the title of the patent application. That stuff just doesn't matter. The figures, those things all exist to support what's in the claims. And if it's not in the claim, it's not entitled to any sort of protection. So in order to infringe this claim right here, somebody would have to perform each one of those steps as you recite them. So that's the scope of protection of a patent. So what about inventions that are made by AI? So as we all know, these generative AI tools that have recently been exploding can produce all sorts of incredible outputs, text and pictures, images, video, and a lot of this stuff, it can be as good or better than stuff that will be done by a human. So often these generative AI models start with a prompt that's human provided. So, a person crafts a carefully worded prompt, provides that as an input, and then the model spits out some sort of content. Who is the inventor of the content? Let's say there's an invention that's devised using a model. You provide a certain prompt to ChatGPT and say, can you solve this problem for me? And it tells you how to solve it. Well, are you the inventor, or is ChatGPT the inventor? Or what about, AI-generated images? Who owns the copyright on that image? So we know these examples of generative AI systems like ChatGPT and DALL-E and Stable Diffusion. I'm sure a lot of us have played around with them, and they're pretty fascinating, but these questions are really interesting. So a business can obviously streamline a lot of things through the use of these generative AI models, cut costs and things like that, but that could come at a certain cost, because businesses should be aware that inventions that are made using generative AI may not be afforded the same rights and protections under an IP law as works that were created directly by people. So let's go back to 35 USC 101. Whoever invents or discovers ... So this whoever, and that's generally interpreted as meaning a patent may only be obtained by the person who engages in the act of inventing. And this issue was decided by the U.S. Court of Appeals for the Federal Circuit just a couple years ago. This decision, Thaler v. Vital, it considered a patent application that was filed with an AI inventor. The only inventor listed on the application was an AI system. And the Federal Circuit decided that an inventor has to be a person. It has to be a human person. So it started with looking at the U.S. Patent Act, and it says the word individual isn't necessarily defined because that term individual is used throughout the Patent Act. However, the Supreme Court in other cases has said that as a noun, individual ordinarily means a human being, a person. So when used in statutes, that word refers to human beings unless there's some indication that Congress specifically intended something else. And there's nothing in the Patent Act that indicates Congress intended different meaning than a human person for the word individual. So in this case, the Federal Circuit concluded AI cannot be listed as an inventor on a patent application. Because of that reason, the Patent Act defines inventor as limited to human beings. So that in that case, the patent application was not examined because there was no human inventor. The only inventor listed was the AI, and it was refused. So in other jurisdictions, we have usually similar outcomes. So the UK said no as well, you can't have an AI inventor. The EU said no, you can't have an AI inventor. Now South Africa granted patents to AI inventors. And it was the same applicant as this Thaler case in the US. So in South Africa, you can actually obtain a patent for an AI. Australia said no as well, only a natural person although they allow a business or an individual to be an inventor. So that's the issue where you have solely an AI that created something. But what if a human and an AI collaborate, which is often the case to a certain extent? And we see this diagram here that kind of depicts what often happens in these generative AI cases. You have a person providing inputs, including a prompt to this model. The model has been trained on some knowledge corpus that might have, intellectual property of other people within it. Then you get an output from the model, and a person might alter that output as well, and then something might be done with that. But who owns the altered output? Who is the inventor? Let's say it's an invention that is ultimately the altered output. So the USPTO requested comments on this, and actually, I know the slide says the USPTO has not addressed it yet, but since I made this slide, they have. So just a couple weeks ago, the USPTO released guidance on this very issue. And so essentially what the USPTO decided is that you can have a joint inventor, a person who joint invents something with an AI, and how you consider that is the same way you would look at joint inventors who are both people. It's the same sort of factors to consider whether the human should be listed as an inventor. And so those factors include basically how significant was your contribution to the ultimate inventive concept. And things like, how much was your prompt instrumental in producing that output? Did you use just kind of a generic run-of-the-mill prompt, or did you craft a very specific prompt with this end in mind, knowing that your prompt would have a better outcome? And in a case like that, you would likely be an inventor. Also, the USPTO says in their guidance that you don't have to disclose that you used an AI model. So you don't have to mention the AI co-inventor at all. You can claim basically to be the sole inventor as if you just use the AI as a tool to create your invention. And it's a little bit different with copyright, because the Copyright Office has said that you do have to disclose the use of AI to generate a copyrighted work. Although in both cases, the AI cannot be an owner of the IP. So currently, the law says in most places an AI cannot be an inventor and doesn't have these sorts of rights. But I just want to throw this question out there. Should AI be accorded any sort of legal rights such as inventorship? And this just raises some questions. What constitutes intelligence, and does AI have it? We know that AI has access to all sorts of information and that it forms patterns based on what it's seen other human language doing, but does the AI itself actually comprehend any of that data in the way that a human being does? And I would say at this point, the answer would be no. Does AI have a will? And, a lot of the greatest philosophers in history have defined a will as, to will something is to act with an end in mind. I think that was St. Thomas Aquinas echoing Aristotle. And so when you look at an AI algorithm, is that acting with an end in mind? And what would that really mean in that context? Because obviously it does have an end. It's trying to, let's say, optimize some function or something like that. But I would say that, the day that I see a machine learning model decide to disregard its training or its instructions and do something different, that's when we can have this conversation. At this point, I would say that an AI is executing sequential instructions and does not have a will. But let's say if somebody were to posit that an AI does have an intellect and a will, should it be accorded legal rights? And I would say that there would be a legitimate question at that point if you could answer those two questions with yes. So another interesting issue is, what if you train a model using someone else's intellectual property? So in that diagram we saw before, that knowledge corpus, what if that includes other people's IP? And this is something that's being litigated right now. We've heard of these lawsuits. I think the New York Times, Sarah Silverman, a lot of other content creators have sued OpenAI for using their content to train ChatGPT. And these cases have not been decided yet, but it's going to be really interesting to see how it all plays out. So is this sort of use of somebody's IP fair use is part of the question. And there's factors for this. Lawyers love factors. So here's some of the factors you consider. The purpose and character of the use, including whether it is for commercial or educational purposes. The nature of the copyrighted work, the amount and substantiality of the portion used concerning the copyrighted work, the effect of the use on the potential market for or value of the copyrighted work. And so far, like I said, there haven't been any rulings on this stuff. So the EU requires model developers to publicly disclose the things that they use if it has copyrighted material. Japan and Israel have also passed legislation. They allow for the use of copyrighted material, but Israel restricts training of a model on a single artist's work. So there's more restrictions if somebody wants to make an Eric Moore machine learning model trained based on my patent applications to crank out an automated patent application. Israel would put some restrictions on that. Another example, Adobe has asked content creators to tag their content with this metadata that says, I don't want this to be used for training. It's kind of an interesting idea, and I think we're going to see more of that. And then the question will come, what happens when that's ignored? And inevitably, models are trained using stuff that people have explicitly flagged as not being intended to be used for that purpose. And what sort of damages will be involved in these cases? What contribution does one item of training data really have to a gigantic model with millions of parameters? I don't know. It's all going to be very interesting to see it play out. Here's another interesting question. Can an attorney use AI to generate work product, such as a patent application? Can I just, phone it in, just tell the AI to generate the application and just sit back and drink some coffee or something? So, no, is the simple answer. But to the extent that AI can be used in the creation of legal work product, it obviously has to be done with extreme care. So we might have heard about these cases of attorneys facing sanctions for citing imaginary case law in briefings because they used a model to generate their pleading or something, and the model just looks at patterns in language and says, well, these types of documents usually cite stuff that looks like this and has this sort of a citation, and it just makes up the text and makes up the citation. And we've had attorneys actually, cite imaginary cases in court and get in big trouble for that, understandably. Another issue is confidential client data, because a lot of these models are publicly hosted or hosted in a cloud that's not under the control of the professional. Obviously, you can imagine all the confidentiality concerns associated with that. Also, there's just accuracy and quality concerns. Does an AI model have the nuance to address thorny legal issues? Let's take this patent eligibility stuff that I talked about at the beginning of the presentation. It's something that's currently developing. There's ongoing litigation. There's new court decisions all the time. There's new regulations. Could you trust the machine learning model to understand that and thread the needle of patent eligibility for an AI-related invention? I would say certainly not, at least at this point. So another aspect is lawyers are required by professional codes of conduct to stay abreast of technology and know the benefits and risks associated with that. So in one sense, lawyers are obligated to understand AI and know how it can be used to benefit our clients. But obviously we have to be well aware of the risks associated with that and avoid those. And like I said, I don't think preparing a patent application, and maybe if you're trying to come up with some generic stock language for a background section of a patent application to discuss the state of the art, you could use AI to help you, get some of that background information, assuming that you read through it and make sure it's all accurate and prune it. But certainly not for the meat of the invention. So, should you seek patent protection for your AI-related inventions? Obviously, having patents will add value to your business. So these are some more factors, some more lawyer factors. Have you developed a new and useful innovation to the training or use of AI? So consider these sorts of questions. Does it provide technical benefits not provided by other technical ways of doing this? Does it solve a technical problem? Does it make a computer run more efficiently? You know, does it make the model train faster? Have you produced a model with fewer parameters that functions the same as a larger model or better? Does it accomplish something that was impossible with prior techniques? Does your technique involve an interactive feedback loop, which is common in machine learning models, to retrain your model as you get new labeled training data from users? And there's an example in the US Patent and Trademark Office's patent eligibility guidelines that says reducing false positives through an interactive feedback loop does recite patent eligible subject matter. Although I'll say that patent examiners are treating this example as sort of out of date, because this was 2019 when those guidelines were issued, and the AI patent world has exploded since then. There's a lot more patent applications, and I think people are looking at it with a slightly more nuanced eye, and just because you're retraining your model with manual labeled training data does not necessarily mean that it's patent eligible. So these are some steps to consider if you're thinking about deciding whether you might have patent eligible subject matter to protect. So one thing to do is conduct invention mining sessions, and I like to do these with some of my clients. You know, maybe a patent attorney sits down with a group of inventors and you talk through a lot of ideas and sort of sort through them, and then the patent attorney will sort of make recommendations. I think we've identified, you know, these 3 or 4 ideas that could potentially be good candidates for filing patent applications. Another good idea is implementing a patent idea submission process. So, you know, encourage your employees to submit potentially patentable inventions and have somebody review those and you know, filter them through. Or offer awards and incentives to inventors within the organization for patent filings. A lot of my clients do that. They will pay monetary awards to inventors who are listed on patent applications that end up getting filed. An important consideration I just wanted to throw in here is that you want to file a patent application before you publicly disclose an invention, generally speaking. Now in the US, there's a 1-year grace period from a public disclosure, and you can still file a patent application in the US within that year. But most other jurisdictions do not allow such a grace period. So if you don't file before you publicly disclose, you're probably barred from filing a patent application in most jurisdictions. The US, like I said, allows that 1-year grace period. Now, what is a public disclosure? It could be anything from a product release that includes that invention. It could be speaking at a conference. It could be, you know, publishing some sort of article or study or something like that. Basically anything that's open to the public to be examined and includes your invention. And you might say, well, if I release a product and it's not open source and nobody really knows how I'm implementing this thing, but the feature's in there in the code, does that count? Yes, it does. If you're publicly releasing the product and it includes your invention in the way that it would ordinarily be used, that is a public disclosure of the invention. So it's just something to think about if you're about to release a product or go live with something. So now is a great time to get into the AI patent game. Stake your claim and protect your IP as the AI explosion continues. I'd like to take some questions from the audience.
I would just ask is, I think it creates a weird negative in what you said there is, please do not copy my work. Or, you know, have we gotten to the point where unless I say something, should the default mentality be, I'm just going to rip this guy off? And I feel like that's a dangerous.
That's an interesting point. Yeah, I brought that up about Adobe asking people to tag content with "do not train" or something like that. And if that becomes the norm, then will it be expected that if you don't tag your work with that sort of a metadata, then are you allowing your work to be used? I don't know if that's how it will play out. I doubt it. I'll say that the law is pretty good about adapting to the real world and how people expect things to work. It's a very rational field, and I expect that obviously these things will be a case-by-case basis, but I expect that the default will not be, if you don't say no, that you're allowing your work to be used for that purpose. I think it's going to come down to a lot of factors and how it's being used. The things we talked about. I don't think that having that growing trend of people tagging work that way will mean that if you don't tag it, you can use it.
Hi, thanks so much. I don't know. Do you want to go first?
No.
Okay. Some people might recognize me. I gave the other law presentation, but I totally punted on the IP questions because I said I am not an IP lawyer. Please go to the other presentation. So I'm going to ask a couple kind of annoying lawyerly questions, but one of them is to amplify a question I got because I'm curious your thoughts. So someone asked me in the audience about cases that I do know of in kind of an earlier generation of ML training, which was the cases against Google and companies like them, right, for training on copyrighted material. Those tended to come out in Google's favor. And to me, I know copyright and patent aren't the same and the factors are kind of different, but to me, that would make me feel pretty good if I were a defendant in one of these kinds of claims. I don't know if that's a good thing, but I'm curious, and this is what the person asked, how transferable that kind of earlier generation of precedents are, how transferable they are to kind of the Sarah Silverman, New York Times type cases. The second question, which is related, is when you put up those factors, I mean, and you said this, amount and substantiality of the portion, of the contribution, the effect on the market value. I mean, just as you said, I mean, that seems like a dead loser for the claimants fighting models that train on like a lot of data. It actually seems to create a perverse incentive from the people creating the data to be as indiscriminate as possible and use as much data as they possibly can to dilute the claim of any given person. That's what the factors suggest to me. I used to practice in Illinois under BIPA, which you might know about, and there is some case law on what it means to profit from biometric data that might make it into these. But I'm curious your thoughts on this kind of wacko situation where the wider I cast my net and the less tailored I am, kind of the more insulated I am from the claim. So I know it's a lot, so kind of take whatever part of that you wish.
Yeah. So I think the first question was about the earlier rulings about Google and things like that, and whether that should make an AI developer feel pretty confident about using other people's IP. And I would say that probably yes. Probably if there are rulings against AI developers for this sort of thing, they're not going to hit them very hard. For some of the reasons that you touched on in the second part of your question, these factors. I mean, if you're looking at a gigantic model that's been trained off of tons of training data, can you really detect the impact of having that one New York Times article thrown in there and that training data? Probably not. It probably has such an insignificant impact to the overall model that the damages would be practically non-existent. So I think that's probably a reasonable way of looking at it. And now, whether that's exactly how it's going to play out, I don't know. I mean, there's policy concerns as well, and people are entitled to protection for their intellectual property. And I do think that the substantiality is going to be a huge part of it. And it's like with the Israel regulation, if you're training an ML model substantially based on one person's work, for example, that a Sarah Silverman model or something that just cracks Sarah Silverman jokes, I mean, that's probably something that's going to run into trouble. But if it's just one item of training data among millions, I just don't think it's going to have that much of an impact on a company, even if there is an adverse ruling.
So online you can find all sorts of non-lawyers opining on IP law, but I'd like to get your thoughts on how using pictures scraped from the internet that any person would be able to access and use to build up their own artistic talent, how would that be legally distinct from what is going on with AI?
Yeah, that's a really interesting aspect of it too, because the whole idea of AI is to mimic how the human brain works, and obviously we all take in data from everywhere and then form new patterns and create things based on stuff that we've seen. And we see that with derivative works, and you often have bands called into court, and they're playing the snippets of their song and seeing how close it is to some other song. Maybe they heard it, maybe they didn't. I don't know, but yeah, it's a good point, because pretty much all creative work is influenced on some level by other people's IP. And so is it really that much different if you have a machine learning model that has been trained based on someone else's IP? I think there's a strong case that it's not that much different. But again, it's going to depend on the extent to which it's being used. Because obviously if you're mimicking somebody directly because you're training almost exclusively on their content, that's a problem. But I think that's a really good insight, and that's probably a good way of looking at it.
And I'm wondering if those tags of "please do not use to train AI" would be as meaningful as somebody tagging on DeviantArt, "please don't practice with my image."
Yeah, you're right. Probably just as effective.
I actually have two questions. First is, are there any rules about how to properly cite your sources or give credit to people when you're using AI? Because I know that that's a big thing in either copyright or scientific papers. And I don't know if there's any way you can do that with AI.
So you mean the data that was used to train the model that you're using to create something?
Yeah, as a user, I have no idea where the data came from. So
Yeah.
what legal obligation do I have to cite my unknown source?
So that's a really interesting question as well, because as a user of AI, it's a little bit different than the creator of the model who's using this various training data to their benefit. So if you're using a model and relying on its output for some purpose, I would say it depends on the output. If the output is telling you some fact that requires some sort of support, then I would say you would need to cite support. And maybe you ask the model, where did you get that data? What's the source for that? And so if it's something like that, if it's referring to some specific fact or some specific piece of work out there, I would ask the model, in a prompt to give you the source. And of course, you can't necessarily trust what the model tells you. The model could make up a source. That's certainly possible. And if that happens, I don't think that the user is in any sort of trouble, because I don't think the user would have any sort of obligation to hunt down where the model got that answer from. You could cite the model, that would be one way to do it, and then just make it their problem. Like, I got this answer from ChatGPT, if you have any questions about it, ask them.
So
To that effect, doesn't ChatGPT have a responsibility? Is there any pressure on them to find your sources, and is there any legislation happening that's forcing that? ChatGPT, the creators of the AI models.
I don't know if there is currently any legislation that's being crafted to sort of force AI developers to cite those sources, but I think that sort of thing is coming. I think that explainability, auditability, things like that for machine learning models are increasing in prominence. And especially when models are being used for critical tasks, let's say self-driving cars, why did the car do this at this moment? That could be something that's litigated heavily, and having the ability to go through and see why the model made a certain decision. Obviously that could be based on certain training data, but it's going to be a difficult thing for a model developer to do, except at a very basic level. Obviously, you can disclose the sources you use to train it. You can disclose, the architecture of the model and things like that. And then if it's a certain type of model, the model can tell you, this was the feature that was most significant to this output or something like that. But in a lot of cases, the model is so complex that it's really hard to trace precisely what it was that led to a certain outcome.
I actually just wanted to comment is that ChatGPT has not brought in reference, but Gemini, which is Google's, will sometimes offer reference data within the actual sites that they got this from. Claude 2 is trying to do it, which is Anthropic's, and both have aggressively tried to get out ahead on citation. So there are groups that are trying to push it forward, and I think they're waiting on the sidelines to see how OpenAI's cases go through. If it turns out to be still a huge sticking point for a lot of legal action, they might continue to push that forward. But I've seen them kind of pull back in the last 3 months. I don't want to overwhelm, but that is just something I've seen with alternative models to ChatGPT. So.
I just wanted to add to your question, if it's okay, that like, there isn't a free-floating legal obligation to cite things in general, right? That's important to realize. Like a lot of citation obligations are social or professional, but they don't necessarily come from the law. And lurking in the background of a lot of this is the First Amendment, right? Like the government doesn't actually tell news sources, maybe they should, but they don't, you know, the ways in which they have to substantiate their information. And if they try, they might get challenged under the First Amendment. There are applications, you know, where, yes, there are legal rules, but in general, it's a pretty free-floating world, and that was true before AI, just like it's true with it.
That's a good point.
Oh, okay. That one, then here, then pick here, then.
Hi.
Okay.
We have tokens. We have speaker tokens.
Okay. So somebody go.
Yeah.
Okay.
I have a question in the artistic sphere. As an artist, I'm concerned for my work and others' work because with AI models, you can specifically train it off of a specific artist's work, but is there a precedent or any ruling under where how much change does the person who prompts the AI have to do to that generated image to call it their own? If it is generated with AI, how much editing do they have to do to make it original?
Yeah, so I think, you know, like most things in the law, it's kind of a gray area, and the law loves sliding scales and things like that. And I have a feeling that it comes down to a case-by-case basis. And if you know, could you convince a judge or a jury that your contribution was significant enough to make the work that's produced different than what came out of the model or something like that. And unfortunately, it's hard to give objective, you know, it's like it has to be 70% different or something like that. It's hard to give that kind of a test because these things are a little bit subjective. And sometimes a small change can radically alter the character of, you know, a work of art or something like that. So I really do think that it's hard, unfortunately, to define, but I think it's, you know, the kind of factors that we talked about before would be the things that you would look at. And it really comes down to how significant was your contribution.
Okay, you've triggered a ton of questions. I'll try to keep the scope very narrow and articulate just a couple. First off, in a reaction to the citations and properly citing references, I think a lot of the requirements have been imposed by academia, and especially in Western culture academia. Some of my international students have slightly different opinions of the necessity of citation. But when we publish, say, dissertations or any academic papers, it's our responsibility to properly cite our sources. But what happens if we are citing a survey paper? A survey paper is a paper about other papers. Do we have to trace it all the way back to the original author? It depends, as Stacy said, it depends on how much you trust your authors. So it's academics, you know, it's our fault. We're forcing people to cite, which is a good thing. Okay, from a privacy standpoint, you really didn't touch on privacy, but someone's question brought up an interesting point. One of from a privacy standpoint, differential privacy is all based on the concept of the inability to discern whether one particular individual is present in one data set as opposed to another data set. So the discussion of dissolution or diluting data to a degree, does the larger the data set becomes, does it actually increase privacy guarantees? Or is that being addressed in the legal sphere?
I would say yes, to a certain extent. I mean, just practically speaking, you know, the larger the data set, the less likely that your data could ever be identified in any meaningful way. As far as, you know, from a legal perspective, I don't know. I don't know that that's being addressed specifically, but just rationally, I do think that the larger the data set, the less the privacy concern. Now, that doesn't mean it's not there, and obviously it depends on the nature of the thing that's being made public or something like that, and it depends on all those factors that we've talked about. But I do think that, yeah, I think you're right. The larger the data set probably makes it less of a concern.
So a couple of questions. I'm no lawyer, but I heard somewhere that basically you cannot, to the point that the gentleman was making about the artistic authorship, you cannot claim author rights on something or on a derivative of something that has no author rights in the first place. So in the context of generative AI, when you have an image that has been synthesized and generated at that point, if you create a derivative out of this, then you cannot claim any author rights for that piece of art. Is that correct?
Well, it's not completely correct. So if the work was created entirely by the AI, yes, that's true. You cannot claim any sort of authorship for it. But if you use the AI as part of the process, but then you create something that's ultimately largely impacted by your work, either in the way that you directed the AI in an unusual and unique way, and or how you change the output from the model. And if your contribution is significant enough, you can be the author of that work. You just have to disclose that the AI was used to the Copyright Office if you're seeking copyright protection.
Okay, so in the context of synthetic data, where you basically start to create more and more data out of data, at that point, do you get to a point where you don't have author rights?
If you're creating something synthetic based on something that you were an author of.
Suppose generative AI feeds itself from generative AI, abstractly. So do you get to a point where you don't have any more authorship rights?
I'd say you would eventually get to that point. If your contribution becomes so diluted by the contributions of the AI that it's no longer significant to the final product, I think you could certainly get to that point. But it would be a case-by-case determination.
Okay, and the second question was about, you talk a lot about patents, but in the industry you see a lot of trade secrets instead of patents. So the choice going for trade secrets versus patents, could you maybe elaborate on that? Why is it that they prefer to go for trade secrets instead of protecting their work?
The advantage of a trade secret is you don't have to publicly disclose how your invention is made and used. But the disadvantage of a trade secret is it's not as clearly defined what rights you have. A patent is something very objective. You have a clear scope that's set out, and the government has given it a stamp and says, we will enforce this against competitors. With a trade secret, it's a little bit more vacuous, a little bit vaguer. That doesn't mean that they don't matter. Obviously, trade secrets are frequently litigated and enforced, but it's a slightly less concrete area of law, and it might not give you as much peace of mind that your IP is being protected.
So I have a kind of tangential question about reviewing of patents. My thought is that would the patent office be using AI like ChatGPT for obviousness determination? And if so, would it behoove me, if I invented a widget, to put it into ChatGPT and see if it comes up, or would that be not advised?
I would say, to your first question, yes, I would expect that patent examiners are now using AI models to do prior art searches, and I'd say almost certainly they are. And then to the second question, obviously, be careful, if it's ChatGPT and it's hosted publicly in the cloud or something like that, don't put your confidential information into a publicly hosted model. That will be the concern there. But if you have a privately hosted model, it's not a bad idea, because inventors often do a prior art search before they file a patent application just to see what the landscape is like, and AI tools are incredibly powerful for that. And if you have a way to do it in a confidential manner, I would be all for it.
Well, I was thinking more than just prior art, but obviousness, or novel, I guess is the proper term. So if I ask ChatGPT, can you improve upon widget A to make it faster, and it produces your invention, then it's obvious.
Yeah, that's really interesting, actually. That's not something I had thought about yet, but I imagine that it probably is not a good idea to try that, because let's say it does produce your invention. Well, I would not then go and file for that patent. But that doesn't necessarily mean that it would have been obvious to a person of ordinary skill in the art, because machine learning models are trained on a much larger data set than the person of ordinary skill in the art. And that's the legal standard. So something is obvious if a person having ordinary skill in your art would look at this combination of prior art teachings and put them together in the way that you did. So a machine learning model is not a person of ordinary skill in the art.
So, sorry, in response to what you said about academia enforcing citations, and we talked about this at breakfast this morning. You know, I think everybody at this conference is waiting to be told what the rules are about citing something, and we're all waiting for laws to come down. I don't think that's going to be for a while. And we, as creators and users of AI, can take the opportunity to set our own standards the way academia does. I was talking to the filmmakers who were here the other day, and I said, you know, after we see a movie, they put up things like no pets have been harmed in the making of this film, right? Why can't they have something in there about AI? You know, and portions of this film were generated with AI, you know, or attempt to source the data sets that they did get. And I just think, like, I hear this artist saying, hey, I'm in the creative world, I don't want anybody to use my art, but I might want to use theirs. We'll have the same respect that you want for your art by labeling and creating our own sense of sort of grassroots, what is appropriate. We rely on those academic citations because it tells us it's not bullshit, right? And so, like, we need that for AI. And if we don't impose them on ourselves and we just sit and wait for you know, our legislature to get together to put laws on this, it's going to be a long way coming. So I think while we can, if we can label our own work and start setting an example, I think that's important. And I'd love to see law firms come out with some basic best practices, you know, regardless of whether or not they're legally enforceable. But we have to act on our own for what is right. We can't wait for our legislature to catch up. And if we don't put pressure on that, we won't be able to tell the difference, right, between good AI in the future and bad AI. So I'm sorry, I'm just on a soapbox, but I can't help it.
Interesting contribution, yeah, and I think it's true. Social pressure is a huge part of this sort of thing, and the more people start doing it, it will be expected, and it just won't look legitimate if you're not showing your sources. So it's an interesting consideration.
So you mentioned, at least with copyright, you're supposed to mention this was helped with AI. Part of many of the previous talks have talked about just how much AI is everywhere, even in, like, if I'm just using Google Docs, AI is showing up even if I'm just typing around. So where's that threshold if I have to mention, like, do I have to say, hey, autocorrect was used?
Yeah, I would say autocorrect does not rise to the standard. Again, this is just the Eric Moore standard.
Yeah, but
I'm not,
that's the extreme no.
Yeah,
but.
So I think, you know, it's the substantiality of the contribution. If AI made a substantial contribution such that if AI could be listed as an owner of the work, it would need to be listed as an owner of the work. So I would say it would be a similar sort of analysis. Is AI a joint creator of the work or not? And if so, disclose it. If not, then I would say it's fine to leave it out.
Okay, so like if I hit the autocomplete text 30 times, like, that's a good story.
Yeah, I'd say that's not something you need to disclose. But again, disclaimer, this is not legal advice. Nothing in this presentation is legal advice.
Am I not cutting anybody off? Okay. So I have a question. Like, obviously you were talking earlier about using AI, using models, and how, like, the patents need to be technologically focused. So you're solving a specific problem in a new way because of this machine learning model. And so kind of the question I have is, let's say I take a model, like just a general transformer architecture, okay, as a basis, not the plan, but, and I want to apply it to a specific industry that historically has used maybe mathematical models to solve specific information. And instead I want to utilize that approach to solve, you know, the same problem, but using now this new ML model. Is that the kind of thing that would be patentable? And if so, how fleshed out does that have to be? You know, you have to have actually implemented something, proven that it does the job, or can you just simply lay out the way that you would accomplish that without actually having done it yet?
So it depends, you know, the typical legal answer, but these are the sorts of things you'd want to consider. would it be expected that using a transformer model in this particular context would produce the outcome that you're getting from it? And if it would be expected, then it's probably not novel. It's probably, at the very least, it's obvious. That's the issue. Obviously, the patent eligibility concerns are one thing, but I think with what you're talking about, a primary concern is novelty and non-obviousness. If you're looking at an existing model just being used in a new context, that does not mean that you can't do it. You can't patent it. We do patent things like that, but it depends on what is the model, how would you expect it to behave under these circumstances, what sort of inventive step was involved in figuring out that it works really well in this context. Are you using some sort of unique combination of input features to the transformer that make it produce better results in this context? And how does that differ from how the transformer would conventionally be used? Those are the sorts of factors you look at. And if you're filing a patent application like that, I would be as detailed as possible, because there's a high likelihood that you're going to have to get very specific in your claim. Because if you're just going to claim, running a transformer model in this architecture, providing an input, getting an output, nope, that's not going to get a patent on it. But you're going to want to include as many implementation details as you can, and then explain why those implementation details are unique and produce good results that are potentially even unexpected, or not something that would have been obvious. Those would be the things I would consider.
So just as a follow-up question to what the gentleman said and on the artistry question, so when you build molecules, for example, molecules are patentable, right? This is how pharma works, in a sense. Now, a lot of these molecules today are built using engines that pretty much scout a search space. And at the same time now, they are adding LLMs to them so that they're able to hop into some other configurations that the engine by itself would not find. So at what point is this molecule patentable, in a sense, right?
Yeah, so there's been case law about this sort of thing, about trying to patent biological entities that have been created through human ingenuity. And the factors are things like, is this something naturally occurring, or how different is it from something that would be naturally occurring? And it is possible you can obtain patents on things like that, assuming, again, the inventorship question might come into play here, because if you're using the LLM and it's really the LLM that's producing this unique combination that works well, it could be that you're not an inventor, unless you crafted the inputs to the model in a unique way that allowed it to produce this really good output. And then if you're talking about the ownership of the actual the molecule that's produced, it's the same sorts of considerations, I would say. But it's certainly possible, assuming your contribution was significant. That's right. You don't have to declare it as a co-inventor if you qualify as an inventor as well under the factors. So let's say a hypothetical, you use an AI with very minimal human input, it produces this molecule, you file a patent application and list yourself as the inventor, you don't disclose that AI was involved, and you get a patent issued on it. Well, if a competitor finds out, the AI created this and the person didn't really contribute, they could file a challenge to your patent. It's called an IPR, and they could bring this evidence to the patent office and say, this person is not really the inventor of this application. The patent would be invalidated. You do have to be certain that you are an inventor, but assuming that you are an inventor, you don't have to list AI as a co-inventor.
Okay. Obviously, this is a very complex topic, and I think, as with so much of all this, just we're at the frontier, aren't we?
Absolutely.
It's crazy. Well, I think that's probably about all the time we have questions for this session. Thank you all for attending this. Eric, thank you for that extraordinary presentation and all these incredible questions. So thanks very much, everyone.
Oh, thank you, and thank all of you for the great questions.